this very important session. Let's all stand, and we're going to ask Pastor Eversley Pemberton to open us up in prayer at this time.
Let us pray. Father, we give you thanks for this new day you've given us, and for the blessings that come with it, the challenges that come from us. And we come here today, Lord, because not as pertaining to the church, and the use of songs. We ask for guidance and direction. We give you unto the dignity of all of the peace, guidance, goodness, in Jesus' name.
Amen. Amen. You may be seated. All right. Again, as I said, I'm glad that we are here representing, at least from what I say, a cross-section of churches throughout Nevis, and we're glad that you have made it possible to be here. Some people indicated the time may have been an issue, but we're glad that some of us are here. As I indicated earlier, we are also streaming live on YouTube, and so in case some members are not able to see it, they could probably go back over it and have a look at it. All right, we are glad to have with us Miss Jihan Williams. She is from St. Kitts. She is St. Kitts born as well. She is an attorney at law. She would have graduated from the UWI Caville campus in 2005 with a bachelor's in law, and then on to the Norman Manley School, and would have left there in 2007, was called to the bar shortly thereafter, then went off again and did a master's in intellectual property law from Queen Mary University in England. She is employed by the federal government as the Registrar of Intellectual Property in the Intellectual Property Office, and has extensive experience in intellectual property. She is often called upon by institutions to share her knowledge, and in my opinion is very well traveled. She is a past state scholar for the Federation of St. Kitts and Nevis in 2001, and is also an author and loves meeting new people and exchanging thoughts and ideas. Without any further ado, I'm going to welcome our presenter for this morning, Ms. Jihan Williams.
Good morning, church. It's not Sunday, but we're in a church, and of course, good morning, and you're representing churches, so good morning, churches. Now, this is a topic that I know there's a lot of buzz surrounding it, and that people want to understand what's happening with their live streams, and generally, what's the basis? How can we prevent it? What can we do? Am I right? That's what we're here for. Mind you, I love an interactive crowd. So don't feel too shy to ask questions. I want at the end of this to make sure that everybody walks away with certain information. So can we have the next slide, please? So some of the information that I know that, wow, this is challenging. Some of the information that I would like for us to walk away with this morning is a basic understanding of what intellectual property is, shortly referred to as IP, what it covers. For the church, this is a very important one, because I think sometimes the church doesn't see itself as a creator. I know we all serve the mighty creator, but we were gifted with gifts that make us creators as well. I would like for you to walk away with an appreciation of how the copyright system works, and by extension, why you have challenges with live streams and things of that nature. A basic understanding of your rights and responsibilities as churches. And of course, I cannot come and not leave suggestions that I hope that the church would consider going forward. Next slide, please. So, what is intellectual property? It is property that is intellectual. It is that simple. It is what is referred to. The simple definition is creations of your mind. We understand the word property in the context of land and a car and a house, but the things that we create with our minds also have qualities and is treated in the law as property as well. So our things that celebrate or record our ingenuity, our intellect, our creativity, the output of those things is considered intellectual property. Now, there are different types of intellectual property. So you might hear about copyright, you might hear about trademarks, patents, designs. There are about 8 different areas of intellectual property, and each one covers something different. So, for example, when we're talking about copyright and copyright protection, we're talking about original literary, dramatic, artistic, and musical work. It's protecting the originality of those things. When we talk about trademarks, we're talking about specific brand elements that help to differentiate one enterprise's goods from another enterprise's goods. So I have in front of me here a bottle of Island Purified Water. So Island Purified Water would be a trademark, but I would be able to tell another water producer would be using another name, and that becomes that brand's trademark. So we're not necessarily protecting originality, but we're protecting the unique brand. This is germane to this particular business, this particular good, and this is essentially what I do at my office, or what my office does on practically a daily basis. We receive applications from companies locally and internationally trying to have their trademarks registered in St. Kitts and Nevis. Patents, on the other hand, this is when we start talking about inventions. So this now relates to the protection of a new invention. And new means new to the world, not new to St. Kitts and Nevis, but new to the world. So you've come up with something that doesn't exist on the market, and you want to patent it to ensure that you have the exclusive right to manufacture and produce this invention that you've created. Next slide, please. Can everybody see? Or I'm just the one visually challenged? Okay. So let's talk about copyright and the church, because from the correspondence that I received for this session, it appears that this seems to be the area that the church is most interested in. So, as I mentioned earlier, copyright protects original literary, dramatic, artistic, and musical work. It also covers sound recordings and cable programming. Now, all of these might just sound abstract, but when we say literary, we're talking about words that are intended to be spoken or sung. So here we're talking about books, poetry, song lyrics, sermons. These are copyright protectable material. When we talk about artistic, we're talking about photos, drawings, sculptures, things of that nature. Musical, that goes without saying, music. And dramatic, we're talking about plays, movies, theater productions. So when you create something that falls into one of those 4 categories and it is original, you have created material that is copyright protectable. I am almost certain that everyone in here has created at least 100 pieces of copyright protectable material, especially the pastors.
Are you saying that it's copyright protected or copyright protectable?
It's protected, but that's my little, you just blow up my spot right there. but protectable, essentially, we say protectable because protectable is suggestive that maybe it might not fit. But if it fits, it's protected. So protectable, what might make something protectable is maybe it's not original. So then it might be, part of it might be protected, while some other parts might not be. But essentially, anytime you've created something that is original, and it falls into one of those 4 categories, you have created copyright protected material. So in the next, I can explain to you in 5 seconds how you protect copyright material, starting now. Thank you. You do nothing. There is nothing to do. By virtue of creating it, you have the statutory right of copyright protection. You don't have to apply for anything. You don't have to register anything. But because by law, it is an automatic right, there is no further step that has to be taken. Yes? You have a question? Oh. There's no further step that has to be taken. So it is an automatic right, and it is a statutory right. It also is a right that extends to 183 other countries across the world that are members to what is called the Berne Convention. So St. Kitts and Nevis is a member of the Berne Convention. So that means that if somebody from Nevis produces a book in Australia and somebody in Australia copies your book without your permission, you have the right to sue them in Australia based on the connection with the Berne Convention. Copyright is the only area of intellectual property that has that level of cross-border protection. For trademarks, it is dependent on the jurisdiction. So if you register a trademark in St. Kitts and Nevis, it is only protected in St. Kitts and Nevis. So if you're doing business in 47 other countries, you're going to have to apply 47 times. So examples, like I mentioned, church bulletins. These are words that can be spoken or sung. Facebook posts. I know people like Reverend Ron takes a very long time writing these long posts. That is a product of his creativity and intellect. So he creates intellectual property each time he uses his intellect and creativity to write a Facebook post. The church plays that we see, especially at Christmas and Easter time, the script, the person who wrote the script, the performance of the play, this is copyright material. Sheet music, live stream recordings, devotional material, all of these things are copyright protected material.
And just to clarify, you said these things are copyrighted automatically just by virtue of them being created. So that prevents somebody from using it, repurposing it, or
No. It doesn't prevent somebody from doing that. By virtue of it being automatic, it means you don't have to do anything to get copyright protection. It's a right that is like citizenship. All you did was be born and you got citizenship. However, you have a passport that is proof that you are a citizen of the country. So if we could go to the next slide, actually. So if it is a situation where you've created something and then somebody copies it, it's in your best interest to have proof that you are the creator. But you don't have to do anything to get copyright. You have it by virtue of creation, but it's always wise to create somewhat of a paper trail, for example, when you've created something.
So it's kind of land. The land is yours, and we want to make sure you have a title to say.
Land is a bit different because it could, you have to, I won't get technical, so let's just say yes. Let's just say yes. But it's just that nobody has to say, oh, you don't have a certificate to prove that you have copyright, so you don't have copyright. You don't have to get a certificate. Granted, there are people who register their copyright, their material to receive a certificate that helps them prove that they're the creator. But it's not mandatory, but it's something advisable. We could always go into that more if you're interested. Now, copyright protection lasts for the life of the author plus 50 years after they have died. So even if you do a sermon today and you pass away 20 years from now, you would have the right to prevent somebody from using your sermon while you are alive, and even after you're dead, your family can challenge the use of that sermon for 50 years. We're actually in the process of extending that in the law to 70 years. Now, this is the important part. As the copyright owner, you have certain rights. Or as a copyright owner, they have certain rights. These include the right to reproduce the work. So photocopying, putting it online, taking pictures of it. You've reproduced somebody else's work. You've created another copy of somebody else's work. Only the owner of copyright material has that right. So if you copy somebody else's work, you photocopy an entire book, that is copyright infringement because you have reproduced the person's work without permission. Issuing copies to the public, only the owner has the right to do that or to authorize that being done. So live streaming, this is one of the rights that comes up. You are giving other people access to somebody else's work without their permission. Playing or performing or exhibiting the work in public. This is where the live stream issue really comes up. This is where a lot of us have a hard time accepting or understanding why this is even a law. So this essentially says that if you want to play or perform, let's talk in the context of music, if you want to play or perform somebody else's song in the public, you must acquire their permission first.
That's if you're live streaming?
No, this is general. This is church. This is open air meetings. This is anything where someone off of the street can enter, or anyone in the public can have access to what you're playing or performing. So I had a question? Yes.
Okay, maybe you need to explain the difference between the two.
Playing and performing?
Yeah, when we are live streaming in church and copying, like you do somebody's song.
Oh, like a cover?
Yeah, like somebody has to prove, like what you're saying there, somebody has to prove that the song belongs to that person. Mm-hmm. And there are songs that are for public domain. And they've got you can't really trace the owner, you know.
Can I ask you, what do you think public domain means?
Yeah, public domain, they're just like hymns done, but they were not like reproduced, and you can't really trace the owner. But they started somewhere, and somebody started them, and they went into the public domain, and you can't trace the owner. We've got quite a number of songs like that. Yeah.
When you say you can't trust the owner, I'm trying to trace. You can't trace the owner.
Yeah.
Your ability to, or inability to trace the owner doesn't necessarily mean it's public domain. Public domain means that the author has died and 50 years has passed. So there's no need for anybody to ask for permission because that time has elapsed. So the period of protection has ended. When the period of protection for a work has ended, it enters into the public domain. So it's not dependent on you being able to trace the owner, because you might use somebody's song to do a performance, and they find out about it, and then they sue you, and then they can prove that they were the owner, just that you didn't know who it was. But after they've proved that, you may be guilty of copyright infringement. So it's not about your ability to trace the owner. It's about whether or not the period of protection has come to an end for it to be public domain. So we sing a lot of very, very old hymns that are probably out of public domain. But, however, let's say there is a very old hymn, and we'll assume that it's out of public domain. But then, yes, Amazing Grace, good example. But then let's say Ron and I decide we're going to do a duet, and we're going to add our own musical arrangement to Amazing Grace. If you copy the version that we've done, the version that we've done is copyright protected. Because we're still alive. We're still alive, and it will be protected for at least 50 years after we've died. Sure.
Following through with the same thought, does this affect persons doing special songs, somebody's song using their words?
Special songs?
Songs in a church service where you have somebody doing ministry song, and they're going to...
There's no exemption for church, except that, and this is later on in my presentation, but our Copyright Act says that you don't need to ask for permission if it is for charitable purposes, if the music is being played for charitable purposes. However, that section has been flagged as a section that we're going to have to remove from the Act because it is too broad and is not going to be accepted by treaties that we want to sign on to internationally. So there is scope to maybe add some carve-out space where the church doesn't have to ask for permission. It's there in the law now, but the mere fact that churches in St. Kitts and Nevis are getting their live streams disconnected and flagged, it means that the international community is not accepting that provision. Yes. Well, yeah, let's go in order. Yes.
Yes, as you're speaking there's a church program that I watch every Sunday. It's from England in one of our Methodist churches, and I notice after each song they have this CCL license, even if it's a very old song.
Mm-hmm.
So what does that say for us?
That's coming up. That's coming up. That's coming up.
My question was similar to what the lady asked about in churches. When you do praise and worship, we tend to do a lot of the more contemporary songs. So they're not in public domain.
They're not. They're not. Assume once the singer is alive, not in public domain.
So every time the worship team sings the song, are we infringing on their, or that falls under the charitable part of the act?
We can't rest on the charitable purposes provision.
Okay.
We can't.
Not even as churches.
Not even as churches. Not even as churches. Not. I think it said spiritual and educational. I believe it is purposes, but it's not something that's going to save us unless maybe somebody sues you right now while the law is in effect. You might be able to get away with it, but we are hoping to change the law, and that will not be a part of the law this year. Yes.
Okay, I don't know whether it's different. In academics, we call it plagiarism.
Mm-hmm.
Now, if for any reason, before you perform, you acknowledge that this song is done by so and so and so and so, will that be infringing like the copyright? If I acknowledge.
That is on the same level of, when you put on social media, I do not intend to infringe the copyrights. It doesn't save you. It merely acknowledges that you are not the owner. But based on the law, you have to receive the permission of the owner. So acknowledging is good, but it won't save you.
So when you do a hymn song, of course it's written by so and so, but it's a hymn song, you still need permission?
Well, if it,
From
again,
the book?
you'd have to check, is it in public domain? Because a lot of the hymns, the lyrics are in public domain. But remember, I just gave the example of the different versions. Which version are you doing? It can get very technical and ticklish, but there is an answer to get out of all of this that we're going to get into.
Because I was of the idea that these songs, like for instance, let's take an example of the song that we're talking about, The Amazing Grace.
Amazing Grace, yes.
The Amazing Grace, it's actually in public domain because I thought of it and I sang the song. Now it's in the public. But the original, it's not, it's just a song which we used to sing in church.
Yeah, but when it's in the public domain, that means the public can have it. The public can do whatever it wants with it. So let me give you an example. Jamaica has been trying to extend their period of protection. So in St. Kitts and Nevis, it's 50 years after you've died. Jamaica has been trying to extend theirs to up to 90 years because they're trying to protect Bob Marley. Because if the 50-year, the 70-year period runs out on Bob Marley songs, then one, the Bob Marley Foundation won't be able to get royalties for his music, and then any and everybody could do whatever they want with Bob Marley's music, and he's such an icon to the country. So what people want is for songs to go into the public domain so they could do whatever they want with it. They don't have to ask for permission. They don't have to acknowledge anybody. But once it is still protected, you have to ask for permission to use it. Yes. Oh yes, his hand was up first.
You mentioned earlier Amazing Grace and somebody changing the tune. My question is, I create a song with a particular tune, somebody takes it and puts his or her own tune. What is infringed there? What's the situation there?
They've infringed the music. We're gonna get into that. I like that you all want me to go ahead, but they've infringed the music, not the words.
So the question is that what is being done to protect the churches within the
The church has to say what it wants. Right now, the law is too wide because charitable purposes is too wide. So if we want to carve out something for the church, we'll have to then think of what can safely be done for the church in a way that doesn't make St. Kitts and Nevis infringe its responsibilities under international law. So right now, for example, there is a carve-out space or an exception for academic institutions. So there's exceptions for academic institutions. There's exceptions for libraries. So a library has the right to copy a book. Let's say, for example, if it's the last copy of a book that they have. Academic institutions have the right to copy 20% of a book. You can't copy the entire book for the whole class, but you can copy up to 20% of a book. So that's what I'm talking about, creating these kind of carve-out spaces for the church so that you're able to do your work without infringing on anybody else's copyright.
Okay. But then it doesn't mean then, because what I'm hearing here is just basically in reference to the actual live streaming. So if you're having a church...
No, I'm not talking about live streaming alone. I'm talking about church on a
regular
Sunday,
basis.
Tuesday, Wednesday, whenever you're doing anything where the public has access. Whether it is they walk through a door or they click on a link.
So who's monitoring?
The owners.
Who's going to be monitoring?
The copyright owners, the people who own the songs are the ones who monitor. Those are the ones who hire different persons and use different technology to flag live streams and things of that nature. So there are people who monitor this kind of work.
No, I'm talking about really, okay, Sunday is church or Saturday is church, and we're singing a particular song that is owned by Miss Esther Cheer. Who is monitoring that particular service to say, well, I have sung that song and I have infringed on somebody's rights?
Well, the thing is, we have never had a copyright case go to trial in St. Kitts and Nevis. We've had copyright infringement claims that have been settled out of court, but we've never had a situation where there is a judgment because, one, our market is not heavily monitored on the ground. Live stream is a different ball game. Two, nobody's paying, I think it's really that, nobody's really paying attention to what we do on the ground. But if that changes, then you wouldn't really have a defense. So please don't say Miss Williams came and say, well, nobody does watch you, so do what you want. That's not the case at all. Yes.
I once heard that choruses are in the public domain. Nobody really owns them. Is that so?
That's not the case at all. It's not. It's about how long it has been created and whether it is still protected. So you have to bear that in mind.
Okay.
I have a suggestion. Maybe some of our questions going to be answered in the presentation. So if the presentation is allowed to go on.
So
then at
let's
the
have
end.
the last question, and then we could move forward with that. Thank you for that.
Referring to something, the carnival, Calypso show, was that a copyright matter when the young lady, they said she used somebody else's lyrics and something like that?
Reproduction. So you've taken somebody's song and put it in yours. That's reproduction. We lost the. So, I guess while they're working to retrieve that, no, it is not something that I think our people are comfortable with, that we have to ask for permission to sing songs and to play songs in public. And I always have a great challenge with churches, because the thing is, you're doing the Lord's work, so you should be able to sing as you wish. But what we always have to bear in mind is behind every song is a creator who has rights, a creator who has the opportunity to gain income through licensing fees. So when you have to ask for permission, that's called getting a license. And when you pay for a license to get the permission, then those fees go back to the creator. I think that's my next slide. We could go to the next one. Yes. So copyright is owned by the creator. Not when in the context, well, we're going to talk about the music, but generally when you create something, it is owned by the creator. If you create something in the course of your employment, however, the law says that the employer is the owner. So if you're in a bank or a church even, and you come up with, well, let's not say the church, unless people are actually employed by the church, but let's use the bank. So you work in a bank, and you have this presentation to do, and you come up with a manual. These are the procedures for doing XYZ, and the end product is the manual. The manual is copyright material, but because you created it in the course of your employment, and because of your employment, it belongs to your employer. So this presentation belongs to the government of St. Kitts and Nevis, although I was the one that did it. However, it is always open to persons to go to their employers and say, I have created this, and so I want to be the owner of it. If the government of St. Kitts uses this presentation after I'm gone or somewhere else, they still have to acknowledge me as the one who wrote it, but they're the one who own it. So if somebody wants to buy it or somebody wants to copy it, they have to go to the government to get permission, not me. So it's something to bear in mind in the church. Because if people are doing things for the church, you need to be aware of who owns the material that they're creating. So if you're employed by the church, maybe your sermons belong to the church. Sure.
Is there a difference, for example?
There is a difference between being employed on contract or contract for services. So if I am employed on contract, then I am employed, because as pursuant to this contract, I'm doing the work for you for which I'm getting a payment every month and so on. However, a contract for services now might be a situation where I am my own boss, but you have hired me to do this specific task, which is write a manual. So when I've done that manual, you pay me and I go my way. But even in that situation, in the latter situation, I would be the owner. But in the first one, it would belong to the employer.
But I think many churches...
So it's not just about payment. It's about the arrangement that you have. Is it something that's ongoing? Are you being paid on a monthly basis? Is whatever is the situation, you have to consider that.
I think some churches fall into a totally different category, where, for example, you have, in respect of sermons, you have some churches have lay preachers. They're not, you can't say they're employed, they serve freely, they are not paid. If they create a sermon, a work, I would think that belongs to the creator, not to the church.
Well, in a situation like that, yes.
Okay.
But if the church is paying you a monthly salary, there might be a situation where you want to consider, you want to have that conversation of who owns it. Because let's say one of these days you decide to publish a book of all your sermons, and it starts making money. The church might say, we're entitled to royalties from this book because these are sermons that you created in the course of your employment. So it's things to consider, and nobody thinks about these things until confusion happens. So I'm just giving you the heads up before the confusion. Think about who owns the material that I'm creating for the church. Now, there are some exceptions where you don't have to ask for permission. For example, if you're reporting on current events, you are using it for your private, domestic, non-commercial use, for use in academic institutions, and like I have my asterisk there, for charitable purposes.
Private use, you pay home.
Yes. Yes. For yourself, you enjoy it as you see fit, so you don't have to ask permission to play a CD that you bought or something like that. But if you now want to take the CD and play it at the church bazaar, that's a problem.
So these, let's say these young fellas with this big sound system in their vehicle choose to park up by the square and play their music.
Now it becomes for public consumption.
In their private vehicle?
In their private vehicle, but it's for public consumption.
No, I'm playing it for me, It's just that
other people just happen to hear it, but you're in the public. You're in a public space.
Okay, so if I go in my yard and play it, and it's this whole village still hearing it.
Well, in your yard and the public hears it. Can the public enter your house? That's the issue in determining public versus private is always access. Can somebody just walk in? It's ticklish. It's a ticklish situation because I could see how it could be considered public because you said the whole neighborhood. You ain't say the four houses right around you. Yeah, but you're doing it for you. Let's say, and maybe that's the same result for the guys by the square. But let's say now a bus where you have passengers coming in. This is adding to the value of your bus because some people like the loud music blaring in their mind. So then it would be that situation where in that situation it's perhaps easier to say that it's public for public use. Yes, bar, restaurant, something like that. Yes.
If I may piggyback on what the gentleman was trying to answer, you can always look at the perspective of what you consider noise pollution. So as playing loud music in his yard, he's fascinated as his own private entertainment, his own self-happy hearing. But somebody on the other hand may be offended with the volume of his noise.
Oh no, that's not a copyright issue. That's the police. Yes.
He's concerned that he plays as a right place, at his own leisure and pleasure, at the volume level, like him. And I'm only playing it for me, but somebody else who is hearing it is affected. Can have the conversation taken into consideration. Because you might say, I'm only playing it for me, for my own entertainment. But if somebody else is hearing, some will like and they will enjoy.
So that,
some will not dislike.
that's what I was saying, that it's a difference when you start talking about, like, you know, your neighbors versus your whole neighborhood. So then that's where that noise pollution issue might really come into play. Yes. To make loud noise? Churches don't ask for the noise permit? You don't have to? Yeah, well, I know St. Kitts say they have to. Yes, let's hear the question.
What are the proposals that you are making? Because you said the charitable purposes would have to change. So what are the proposals you're making where the church is concerned within St. Kitts and Nevis?
I can't make the proposal. That's why you all are here. You have to tell. No, here's the thing. You have some leeway. So take what I've said into consideration about schools, where schools have the leeway to copy, but just not the whole book, 20%. A library has the right to copy, but only in a situation where perhaps it's the last copy and you need to preserve it. Is there a situation in church where we could create a carve-out where the churches are able to have service or have some sort of activity where you don't have to ask for permission, but we have to understand it can't be everything.
One can't just have a church an academic institution. It's a place of learning, it's a place of teaching.
That's a good argument. That's we could perhaps extend it, but academics is written in the context of copying, reproducing. The church's issue, as I know it, is about playing music. Playing music. Is there large scale copying happening in the church? Are you all copying Bibles for people or some?
Academic part is about the teaching. It's about reproducing people. It's about reproducing lives.
No. Reproducing work. We're not reproducing.
So this perhaps can be a particular argument.
I take that on board. But I'm saying that even if we extend academic institutions to the church, it won't solve your music problem.
If you sing in the Bible.
No. Singing the Bible, that's protecting the words. Coming up, we're going to talk about how a song is split in two parts, the words and the music. So you're just protecting the words, but you want to be able to protect the music as well.
Okay.
Sorry?
Can we put it this way? Like, church is non-profit, right? Church is a non-profit in this organization. And we've got charitable purposes. Can we put that in the same category where church is doing it for charity purposes?
It is actually written in a way that says that once, for example, if you're having an event where you're collecting an admission fee, you wouldn't have to ask for permission if the proceeds from the admission are being used solely for the church. But then that's still very wide because all of your activities would fall under that category.
Yeah, because I see that as a door or leeway where she's talking about the academic and the church. Because I feel like because it's non-profit making organization, whatever is done there is for charity. So we
Yes.
can use that as a door.
No, but I'm telling you that
To make an
already,
argument.
it's already like that, and it's still a problem.
It's what?
It's still a problem. Yeah, not for profit. All of the proceeds are being used for the work of the charity.
I think we have to bear in mind that these producers of this music, they are making money. It's about making money.
Yes.
And if we are going to use their production and they want to make sure that they're getting benefits from it, because the music, really, these authors and producers, it's all about money for them. If, for example, I was going to ask the question earlier when we close up. For example, in the States, people are always suing in the States. You have people like the Israel, you have the popular
Maverick?
Hillsong.
Yes.
He plays song all the time. Is it a matter that some of these producers, Christian authors, they allow the churches to use them to your knowledge, why they're so widely used and we haven't heard of any activity in the States in particular?
Come into that. That's next, I believe. Yes, we could go to the next slide, because I think that would be, yes. So everybody knows that picture and where that picture comes from. C.C. Winans' version of Goodness of God. That song has 5 writers. None of them are C.C. Winans. There are 26 registered versions of Goodness of God. C.C. Winans is just one. But every time the goodness of God is played or somebody does a version, those 5 people are who get the money. Because they are the creators. They are the authors. A song is split up in 2 parts. The composition, which includes the lyrics and the music, and the production or the master sound recording, which is the first recording, studio recording of the song. This is where now a producer gets in and they might add, some editing and musical additives to the work, but you have a recording at the end of it. So those are the people who own music, not the person who you see on stage. The person who you see on stage might be a writer. So popular, what's his name? Chandler Moore from Maverick City and Naomi Rain. These are people who also write. So while they are writers and they are performers, but they own the music when you are a writer. You get the right to perform it. When, remember, play, perform, you get the right to perform when the author authorizes you to perform. So what we have, to answer your question, is a situation where people are paying licenses to play and perform music in public. Or they are getting, well, it's always licenses. Any which way you put it is a license. The question is, do you pay for it or not? Because an author might say, you know what, for this church, they don't have to pay me anything. I'm just going to give them the permission for free. But getting the permission is called a license. So when I speak about music licensing, that's what I'm talking about. Acquiring the permission to play music in public. So that's what churches have to consider. Do you get licenses? Should you get licenses? As far as I know, we don't have any churches that are paying licenses right now. That just means that should any of the creators find out that their work is being used without their permission, they have the right to sue for copyright infringement. Clearly, we've been going this long and nothing has happened. However, it's something that you have to consider. I like to tell people when I meet people, I tell people I sell insurance, because having to explain intellectual property and all of this is kind of complicated sometimes. I sell insurance. I sell insurance for creativity, because my job is to try and explain to people why people have the right to sue for copyright infringement and what you could do to prevent copyright being sued for copyright infringement. So if churches want to avoid being sued for copyright infringement, there are certain things that you can do, and one of those things would be to start paying for licenses. The CC, yeah, I'm gonna get to that. But one of the objectives, as I said, was for you to understand how copyright music works, and like the gentleman's intervention earlier, if you understand that this is how creators, songwriters, musicians make money, then perhaps it would make a lot more sense. So they write, and you have to ask for permission, for their permission to play the music in public. When you ask for permission to play the music in public, it comes at a fee. That fee is collected through what we call collective management organizations or performing rights organizations. One such collective management organization in St. Kitts and Nevis is ECHO. That was a name that was in the media a lot last December, if anyone is familiar with that. So what you would have to do to acquire a license is reach out to ECHO and acquire the license. I don't make it my business to speak too much about ECHO because I don't want to make any submissions on their behalf and speak out of turn, because our offices are not connected, even though we do a lot of work together. But there's a slide where I have their information if you want to reach out to them directly. So that is how copyright works. This is how songwriters and musicians make their money, even from churches. Next slide, please. Sure.
In regards to copyright issues and such, I'm not sure that the part was touched. In regards to
the mic.
Thank you. In regards to the music aspect, if we look in our Bibles, we will see there is a copyright attached to the Bible itself. You're talking about music, so does that apply to the written word?
Yes.
So to use it, we need permission, not just music, to use the Bible itself.
Any kind of copyright material, you need permission.
So the Bible that we've been using for centuries, I think it is, according to King James, is under the Queen, let's say the monarchy of England. You're saying that we need to get their permission?
No, the scripture, of course, would be out in the public domain, because it's been way longer than 50 years since the Bible was written.
Oh,
but when, let's say, for example, you bought a Bible that has drawings and it's written in a certain font, and there's stylistic differences in this Bible versus that Bible. If you want to copy pages of that Bible, for example, reproduction, then you would have to ask for permission in that sense. But the written scripture, the words itself, that would be in public domain, unless it is a Bible and one of those very new versions created in very recent times. As we go along, there seems to be popping up all these different versions of the Bible to make it easier for people to understand and things of that nature. But ultimately, for example, the King James Version, the wording is in the public domain, so you don't have to ask for permission to put a scripture in your sermon. But if you're copying this particular new version, remember the example I used with me and Ron writing a song? We're singing Amazing Grace, but our version is different and it's new. So that's what you have to pay attention to. What am I using? What am I copying? Is what I'm using in the public domain, or is it not in the public domain? Is it still protected by copyright? Is that clear?
Yes, ma'am.
Okay. So live stream and public performances, and when I say public performances, this is where we're talking about the examples I gave: church service on a regular day, open air services, and things of that nature, where people can walk in and have access to what you're saying and doing. It happens, takedowns and muted portions of your live streams happen because of something called audio fingerprinting. So essentially, the songs that are protected, and artists go to great lengths to invest in this sort of initiative, where pieces of their songs can be picked up digitally. And where it's picked up, it flags the entire video or live stream. So the question now becomes, can you prove that you have permission to use it? And you can always challenge that. I've seen people challenge on social media, especially on Facebook, where their live stream was stopped or muted, and they're able to present proof that they acquired a license. But just naturally, when you use people's material, if there are these audio fingerprinting mechanisms in place on the platform, your stuff is going to get flagged. And it's going to get flagged faster when you use pre-recorded material. So when you use a track versus the worship team singing something at church, pre-recorded music gets flagged faster. So we spoke about the licenses, and so we need, that's where all of this is going to come in. You need the licenses. We could go to the next slide, which I think is, we could go to the next slide. Yes.
So I had a friend that says he wants to make sure that the clarity is clear. So that to make sure the clarity is clear in this situation, to be redundant, if you are having, even in church, you said talk about pre-recorded, so there's a dance. Mm-hmm. You would have to ask permission.
A dance? The church is having a dance?
No, not the church. As part of the service, a choreographed dance.
Dance choreography was on my list of copyrighted material.
No.
It's original.
No,
so
not that. That's what I mean. But you are playing the song. That's what I mean. The song that you play. Mm-hmm. You should get a license for that.
Bear in mind. Let me. This might help you a little bit. You're not getting a license. You're not getting a license every Sunday. You're getting a blanket license which covers like a year, and your activities for a year. So that's how that works. And then you would be covered. So it's not like today is Sunday, so we have to get a license and we're doing this Wednesday. No, it's just that it's
and
licensed.
if the church, I think you said it earlier, but I just want to reconfirm, church having an event wherever, a bazaar as you said, and there you have music, that ought to be covered as well.
Yes. Once music is played or performed in public by whoever, you need to have a license.
Okay. The question I will ask now is, before the Wesleyan Holiness Church. So can we take one license for all the Wesleyan Holiness churches?
That's a question that you could probably raise with ECHO. I wouldn't be able to answer that question. You have a question?
Question online. What if one places disclaimer, I do not own the rights to the music?
That just says you know whose song you're stealing. That's all that does. It doesn't save you. But like I said, it's you're not exempted. It just means that you acknowledge that you're not the owner. However, I've seen people be more successful when they put that disclaimer. Like your stuff doesn't get flagged as often when you put that disclaimer. However, if there's a claim later on stating that you are guilty of copyright infringement, it won't save you. But it's a good start to at least acknowledge that you're not the owner. Even if, as the question earlier, you don't know who the owner is. It's just not me. Yes. We have a question. Who has the mic? Yeah.
Okay, so there's a concern for the churches, and right now we're being forewarned, so to speak, right? But does that span across the board in St. Kitts Nevis, like let's say to a radio station?
Yes.
If you are an artist and you have songs that are being played on the radio stations, have the radio stations now been given this same information to say, when you're playing the local people's songs, they too need to procure a license?
Yes.
But is it being implemented? I know it's being said, but is it actually being, followed through?
I don't know if any of the radio stations pay it. And this is what I'm saying, where a lot of people are resting on the fact that nobody has ever been sued. So they're not going to do it. It's kind of like if you knew that for the next year there won't be a hurricane, you might not pay your insurance, because why waste the money? That's how some people might see it. But the appeal is being made because this is what the law is. This is what the practice is across the world. This is not something that is generic to St. Kitts and Nevis. This is how the music industry works. But we have been making those appeals. Some institutions have been paying, like for example, Music Festival is supposed to be coming up to date with their payments. So there are people who are paying. For something as big as the Music Festival, you want to pay. Especially since you have a lot of international artists on the lineup, so people are paying attention. Yes.
The internet is flooded, particularly YouTube and Facebook, flooded with not only music, but in the case of the church, it was sermons. Every preacher, well, not every, but especially in the States, I think, people just put their sermons on the internet. What's the thinking behind that then? And they're for general use? One would think they put them there for us to use.
No. They have taken the risk. It's a risk.
Uh-huh.
Do I want the exposure, or do I want to keep my material to myself?
Mm-hmm.
So it's a balance that you would have to take. So for example, let's say you want to be an internationally renowned pastor or a reverend. You will have to put some of your material out to the public so that they can consume it, so that they can become familiar with you. But it's a risk that you run. But let's say, for example, even that somebody puts a sermon on YouTube and then somebody else uses snippets of that sermon in their sermon. Once you can prove that that person saw your sermon and so on, then you could sue for copyright infringement. It's just a risk.
So what if
so
you...
it being out in the public doesn't mean you can't sue for, well, you know, I put it up on YouTube, so I could never sue anybody for copyright infringement. That's not the case. True, but there are some very specific things. There's some very, very specific things that pastors say. Like I was at a funeral the other day. I never heard it before. I don't know if it's somebody else's own. But the pastor said that we only see people 3 times in their lifetime. When they hatch, when they match, and when they dispatch. And I thought that was creative. So if you could prove that you came up with something like that, you can't, somebody else just can't use that and say, oh, you know, that was God.
I think the challenge is, I preach today, right? Maybe about what you're talking about, the thinking, right? But somewhere,
Oh, the mic.
Okay. That thing is not on the public domain, but I hear it from you today. Then I go public. Then who owns what there? Because when it's there.
So let's say Sunday now, when you go preach your sermon, you go tell people, we don't want to see you 3 times a year when you hatch, your match, and your dispatch.
Yes.
And people say, man, that was hot. That was so good.
Powerful.
Pastor was so funny. And then later on, whoever created that comes and sues you. They'll have to prove that you heard it from them. And that's going to be very hard to prove, which is why there's so much similarity.
But that would be difficult.
Yes, it would be very difficult.
That would be difficult.
So they wouldn't be successful in suing.
Exactly. And the other thing, so that's why you see, you know, nobody can own anything like what other people were saying is the same God who inspires us all. So it's very difficult to prove. But number one, I think the other thing also is we don't have the capacity to sue anyone, because I'm here in Nevis and somebody is in Jamaica. How do I track that? How do I do it? I don't have the capacity. So at the end of the day, people get away with it. That's why you see things are flourishing like it's all over on the internet. And nobody can sue nobody.
Because it's extremely taxing, yes,
Exactly.
and it really goes to a lack of capacity.
Yes.
So I agree with you, and that's exactly why I was saying that.
That's why
nobody is doing anything because you've essentially gotten away with it all the time. But it's still my job to tell you what the law is. And if the people come and ask me, how come the churches don't know this? I went to the Nevis Evangelical Association on the 9th of March 2023 and I told them this.
Yeah,
So,
I was
yes.
asking if in that case, if the person who uses the quote, the piece of material from the original writer, in his own presentation now, says, well, this particular portion of my preaching or whatever is taken from wherever, so that the person gives credit to the original writer. Is that allowed?
Yes, that's recommended, actually. Not only is it allowed, it's recommended. So let's get into the recommendations. Please view the material you produce as property. As churches, you all are creating property. I know you're doing the Lord's work and you want the message to be promoted far and wide, but there's still nothing wrong with attaching ownership to things. You might not have the capacity to sue if you see it somewhere else. You might not want to sue because you're just glad that somebody's using the words that you have used to promote your love for God. But if you see these things as property, understand that there are opportunities available to the church. So, for example, that third point there, you might want to consider monetizing your material. You could publish books. You could start recording your own music. There are things that you could do as a church to start generating income for yourself. There are devotionals. If you go on Amazon, there is a devotional for every class of person you could probably think of, except Kittians. You hardly see people in our St. Kitts Nevis publishing books, and it's not a lack of talent. For some reason, it's like we just kind of, oh well, I just write. No big deal. But we could be in the presence of so many authors, and having your record and your voice outlive you is such a fantastic opportunity that I think we pass up. So I would hope that you all see the value in the things that you create and think about monetizing it. Be clear on who owns the material that is produced in and for your church. So, for example, if you've done a website or you've asked somebody to do a logo, remember, ownership belongs to the creator. So if the church has hired somebody to do a logo or a design of some kind, and they do it, and you use it on your shirt or whatever it is you're doing, and then you see the logo being used somewhere else, can you challenge that? The answer currently is no, because the logo or the design belongs to the person who created it, so they have the right to do what they wish with it. You would have to tell that creator that I want to have the rights to this design and have that documented in writing. So don't assume that because you paid for something means that you own it. That is another area of the law where people have been asking for change, because you would think that I've paid the person, so I should own the design. And that's something that we're addressing. But for now, the person who has created it is the owner.
That surprises me.
Think about photography for your church social media pages. The photographer is the owner of the pictures. So if somebody wants to use a picture you took in church in a magazine, they're not going to the church, they're going to the photographer. See how that works?
Yes. So what if one were to print pictures from the internet, YouTube or whatever, to use for, say, children's programs or anything like that? Did you have to take pictures from the internet?
Yes, well, essentially, it's material, it's copyright material, it belongs to somebody, so you should ask for permission, or at the very least, like I said, acknowledge where you got it from. Don't just copy and paste things from the internet. Because it's on the internet and accessible does not mean it's yours to do what you wish. Get contracts and public performance licenses to ensure that your activities are covered. Where you use other people's material, as I just said, at least acknowledge the author or the owner. And my own personal challenge to anybody and everybody, consider creating your own material rather than using other people's material. We're creators. We're Caribbean people. We're like, talent is just a natural, commonplace thing. So we really should start thinking about creating our own material. Next slide, which is the last one. So someone was mentioning this CCLI license. It's not something that I'm too familiar with, but I did, when I was doing my research, I found it. And I saw that Hillsong in particular uses, they license a lot of their music to CCLI. So you can get a license from them. It's US based. I like I said, my disclaimer is I haven't dug deeply into the CCLI, but I realize it is an opportunity for churches to get their music licensed. And I see that it is used widely in the US. And as someone mentioned earlier, she sees it on the TV when they're playing music. There is the information for ECHO if you also want to reach out to them, if you have any questions about the costs or how the licenses would work or anything like that. That's the information to find that out. But that is the end of the presentation, the formal presentation. Of course, I'm open to questions. Anybody else wants to make any clarity clearer?
Online.
Yes.
Is copyright needed for factual information that is found in an article? And somebody else asks, what about entertainment purposes only?
Entertainment purposes. I never know what that means. Private, domestic, non-commercial use. I understand. I'm not quite sure what entertainment means because entertainment could be commercial and non-commercial. So I'm not sure, but I think I see that a lot with the disclaimer issue. It doesn't save you, but it's at least good to acknowledge that you're using somebody else's work as opposed to your own.
So 2 more questions online. The church is having a concert. It invites someone to render an item. The guest infringes someone's copyright. Who becomes responsible, the guest or the church?
The church. The church invited the person. Well, actually both. It would be both.
Okay.
It would be both.
This video features materials protected by the Fair Use Guidelines of Section 107 of the Copyright Act. All rights reserved to the copyright owners. Someone is asking, what if we use that?
107, I believe that is a reference to the American Copyright Act, and we're not in America. It's still, read it again, let me hear.
This video features materials protected by the Fair Use Guidelines of Section 107 of the Copyright Act. All rights reserved to the copyright owners.
But it has to actually fall in the confines of Section 107, which, to my recollection, says things like you can't use the whole song. You can't use it for, you can't use a substantial, I think the wording is a substantial part of the song. So you can't put that notice and then play the whole song, because then it wouldn't be fair use. Fair use is a concept that is also recognized in our legislation that allows you to use snippets of a song. There is no, or a material rather than just a song. There is no set parameter to say 4 seconds, 10 seconds, 15 seconds or whatever. It depends on the song itself. So using that might save you only if it really falls into the parameters of fair use.
Okay. So the answer to the pastor's question, is copyright needed for factual information that is found in an article?
Factual information?
Yeah. I
don't understand what that means. What is factual information? I'm not sure what's being asked, so my assumption is like statistics. I don't know. what's being asked. Somebody else had a question here? I thought I saw a hand up just now.
Yeah, I was wondering if the person meant, I was wondering if the person who asked the question about factual material meant if something that is obviously true that is stated, so the material is generally protected, but in the article there is something that is generally true, right? Would you need permission to use maybe a historical fact, biographical information or something like that?
It could be a historical fact, but the expression of the historical fact would be copyright protected.
Mm-hmm.
So if, for example, somebody might say, I love George, and somebody else might say, the essence of who George is wakens up my soul. That's factual information.
Uh-huh.
But the expression is different. And if you steal the expression, that's copyright infringement. Well, the expression is the words. So you can't, anybody could say, I love George. There is no protection on I love George. But the way that I've expressed it in the second way, I don't even remember what I said. But in the way that I've said it, it's more creative, it's more engaging to it required my intellect. So then that would be copyright protected. So then if you now find George and you want to tell George that you love him and you say what I say, then yes. Because you could come up with your own intellectual, creative way of telling George that you love him. But it's the expression that's being protected.
Online, if we have materials that we want to put a copyright on, where do we go in St. Kitts Nevis?
Oh, that person missed my fantastic 5-second explanation. You don't have to do anything to get copyright protection. However, you can voluntarily register in some countries, for example, Jamaica and the US. It's not available in St. Kitts and Nevis as yet, but that is something that we're working on.
I know years ago, in reference to what the question, we used to say, well, even if you email yourself,
yes,
or you post it to yourself, you mail it to yourself physically.
So that's called the poor man's copyright.
Yes.
Literally called the poor man's copyright, where you establish proof. So it's like I was saying, the example that I like using is if you go into a store and you buy a shirt and you walk out of the store and the alarm goes off and security comes to you and says, what proof do you have that you bought this shirt? If you have a receipt, it helps you prove that you did in fact buy this shirt. So the receipt would be proof. Without the receipt now, you're going to have to go back to the cashier and hope that the same cashier is still there and they remember you. So then it's going to be harder to establish ownership without that proof, without some sort of proof. So what things like emailing yourself and the poor man's copyright, where you mail things to yourself, what that does is it establishes physical proof that at least you were in possession of the material at a particular point in time. So you will be able to produce an email with the poem or the song or whatever attached that said, on the 17th of December 1999, I emailed this to myself, so this helps me establish that I am actually the owner. It's just proof. So things like emailing yourself, we don't really recommend the mailing things to yourself anymore, especially since email has taken over. But you can do things like affidavits as well. But we're working on the registration system in St. Kitts and Nevis because that's one area that persons have requested that we they want to be able to produce this sort of certificate. So my final request to the church is think about how we can carve out a space for you that doesn't unfairly prejudice the rights of authors. One recommendation so far has been to extend academic institution, the provisions for academic institutions to churches as well. But I still think it might need a bit more. But I mean, I guess it's something we can explore more, but it would have to be explored within the next 6 to 8 weeks.
In the legislation, can charitable events be narrowed down to places of worship?
That's a very good suggestion. But that's not, once you know that that's not going to save you outside of the church. We might also consider numbers. Churches with less than 100 or something, I don't know. That's something that just crossed my mind. So again, it would have to be a fair number. Places of worship with less than 150? Yeah, so think about these things and refer them to Ron, please.
Pleasant good morning, everyone. Thank you so much for the presentation. Very well put together. I've learned a lot. My question is on the academic institution and the church. Academic institutions, particularly universities, should be publishing research. If the church wants to also publish research, we collect a lot of data every week, be it Saturday, be it Sunday. We collect a lot of data, demographics of the population who come to church, consistency, all of that. We can easily publish research. How would the church go about doing that?
Publish it.
In St. Kitts Nevis?
Publish it. It depends on how you want to publish it. What, in a copyright sense, whatever you publish, my recommendation would simply be to note who the authors are, so that people who want to use the information know who to contact. So when you see the C in the circle, that's called a copyright notice. So it would be George, where am I stuck on George? C in a circle, George Williams, 2019 or whatever year the material was published. Not quite sure if you're asking me how to publish. That's a whole other session.
Is there an integrity review board established in St. Kitts Nevis?
Not to my knowledge.
So if I could revert the question I asked earlier about the Wesleyan Church and its overall umbrella. Because then if we rock in these numbers, let's say 100 membership, but you couldn't answer the first part, so that might even show us in a bad light.
But then it might be per, what do you call it, a branch?
Well, the Wesleyan Church in a district, a denomination.
Yeah, so where's denomination would mean like per church, yeah.
My question initially was, we are the Wesleyan Holiness, the umbrella that we fall under.
Yes.
So we have the St. Kitts district of the Wesleyan Holiness Church. There are many churches under that umbrella. So I was asking, can the district get a license that covers all its member churches?
That would be
right.
ECHO, but it would have to be. Is it like an international umbrella, Or it's a local, St. Kitts and Nevis
St. Kitts
umbrella?
Nevis, yeah.
Okay, so a St. Kitts Nevis umbrella, and then you would want for
Charlestown, Brown Hill, right.
Okay. It's a question to ask, but again, what we were talking about was, like a benchmark or threshold.
No, because what I said that is that based on the answer to this question, the numbers at the back will change.
Yeah, but maybe the bigger ones shouldn't benefit. Maybe the bigger ones could pay.
I don't know which is bigger.
if you so it would I mean, these are things that you would have to let us know. You want it to be inclusive so that especially your smaller churches can benefit, but if it's too big, it's not going to be successful. So we would have to put some stipulations, and those kind of stipulations is what I'm talking about, for us to be able to carve out a space where churches can fulfill their work, because copyright is all about balance. It's balancing the needs of the authors and creators with the public good. You want to be able to sing songs and worship. You don't want it to be overly prohibitive, and then you can't praise God as you would like. But we also have to be minded that these creators should be getting some benefit. You can't be singing the people them song every single Sunday, and yes, or using them in your radio ads and these things, and nothing is happening for them.
Yeah. You did say that copyright for the writer or the playwright, the photography, their right is natural.
Mm-hmm. Automatic,
yeah. So now, if one realizes that his or her work is being used out there, what steps should that person take, and if your office would intervene to help?
No, that's not my job at all. That's your job.
So you don't give directions?
No, that's your job. It's your work.
Okay.
Our
so what
job is
steps?
to make sure that the law is in place to give you the right to go after the person. That's not for us.
Oh, I see. Okay.
So, yes.
Before we go on, you want to be, I think we should finish before we go on there. There's going to take 3 more questions.
Yes. Switch to the next slide so people can see the information, my office information, please.
All right.
I was about to make a follow-up on what she said. She was talking about what steps. I think it's a valid...
I think it's a very good question, because though we are not talking about capacity, but the how aspect, how do I go about? I think it's important here. You get a lawyer, or
Yes.
we conduct your office. What do you do?
No, our office's responsibility is to administer the legal framework. So where I'm talking about changing the law and making sure that the laws are in place that serve the people and also the creators. Our responsibility also exists with public awareness. So doing these kinds of sessions where we raise your awareness to empower you to take action for your own work. So our office doesn't get involved in giving legal advice or taking action on persons' behalf where their work has been infringed. It would be your responsibility to seek out the services of an attorney who, at the first step, would perhaps write a cease and desist letter. You might think that you can do that yourself. And then if there is no action, then you might want to take the matter to the court.
Okay. So in terms of the law, like we are in navies, we are only restricted to navies. Copyright does not.
No, copyright extends to other members of what is called the Berne Convention.
Okay.
So there's about 183 countries that are party to that convention.
Okay. That's okay.
We had another question.
Thank you.
All right, I think we have had a lot of food for thought, and I think this to me is like an initial thing, because I think we could then start to think, probably speak to your respective people in your churches and see what can we do, and then see how best we can respond accordingly. They did say ignorance is no, what is it? Ignorance is no excuse. So now we know. We can't say that we did not know. And as I said, food for thought. I know Jihan well, and I know that she likes food. And so I got the... So we have the cake of your choice, because I did some research to find out which cake you prefer. And so we have the cake of your choice, basically saying, thank you, Jihan, so that you can enjoy it going down or wherever you will go. And so thank you so much. It has been our pleasure. I definitely learned way more than I even intended to, and we also had some people on the YouTube audience sending questions, etc., etc. And so we want to thank you. Now that we know for sure some of the key things we know, one, we ought not to, especially within the next 6 to 8 weeks, which suggests that there's going to be a change of legislation, be able to sing songs basically without permission, dance to songs without permission, have events, public events, without permission. If you have it home in your yard, then that's a little different, but not too loud that it is for everyone to hear, then that is okay. And that this is because we are taking other people's intellectual property and using it, and that if we wish to do it, it is that it has to be that it's for the lifetime of the person as well as up to 50 years thereafter. So some old hymns, yes, they're in public domain, like Allah, Amazing Grace, but the contemporary songs that we like to sing and dance to and so on, and the contemporary versions of Amazing Grace, or whatever, those two are there. Her numbers are right there that you can contact her and follow up if needs be. Please note that I have no monopoly as yet on Miss Jihan Williams, so, but, so again, yes, if you want access to the presentation, I think one is already here, and so if you just leave an email or something, we could just send it out to you. All right? Yes?
You're supposed to answer to this question. Is it literary, artistic, dramatical, or musical?
Yeah, I have to confirm that I have the right to offer it, but I did pay for it, so we did give. All right, so Pastor, since you want to tie me up, could you close us off in prayer, please? Let's all stand and ask Pastor Otis to pray.
All right, let us pray. Heavenly Father, we thank you for a fruitful and informative discussion. We pray that you would assist us as we seek to be in alignment with the law, since we are people who are law-abiding people, and as people of God, we seek to do what is right. Thank you for the presenter, for the thorough presentation that she did. We ask that you will continue to bless her and to use her in her capacity, and be with all of us as we seek to serve you. In Jesus' name I pray. Amen.
We don't know who's the right to do.